Thank you.
Your Honor, today is the date and time scheduled for a preliminary exam. I believe that Mr. Martell would like to start us off by motioning for Your Honor to accuse himself in this case.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identified.
I did not preside over it.
No. So the argument that the counsel is attempting to...
Well, then I'll let him finish, because I don't know, it did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with 2 search warrants.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue, because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if a defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position...
Does that case clearly apply to search warrants?
No.
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martell.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case applied to something that I don't think that applies to.
Judge,
just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
Judge, specifically this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moved. But
I have read, so that we're clear, because you're playing fast and loose with words. So that is clear. I would have read the search warrant. I would not, don't recall. Then show me the case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Burrell is applicable, and I would also humbly submit, Judge, to the position of the court that anything outside the 4 corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion so I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
All right.
Court recalls case of the People versus Daren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. And I please the honorable court, Edward Martell, Daren Wilson. State your name once again for the record. Daren Wilson.
Have a seat. So, Mr. Martell, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the 24F2 2251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding recusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully,
No, you lied to me.
okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that, ma'am. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear, I do have a lot to say about the law, and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity. Facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that I'm choosing not, and maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case. It's from 1971. It's People v. Pitchford, 3-3 Mish at 299, 1971, their exam judge, and then they affirmed, and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that Your Honor inappropriately approved a search warrant, and we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Just very
Martell?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martell, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recuse for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to misspeak this or in fact, I'm going to pull the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial, and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
but do not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
Might be the most serious yet. Judge Boyd accuses Martell of forum shopping, trying to get the case in front of a different judge he might see as more favorable. That's not just frowned upon, it can be a major ethical violation. She implies that Martell's entire motion was a strategy to avoid her courtroom. Ouch. Forum shopping undermines judicial fairness and erodes public trust, and the judge sees right through it. If Martell thought he could push her off the bench with a flimsy legal claim, this moment proves he picked the wrong judge.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I am the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not co-defendant, is Christopher Harrison. That case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam.
Today's courtroom is on fire, and it's all over one bold claim. Defense attorney Martell is pushing for Judge Boyd to recuse herself, arguing she can't be neutral after signing the search warrants in this case. But hold up. Judge Boyd isn't backing down. This hearing turns from legal debate to full-blown confrontation, with accusations of bias, lies, and even forum shopping. Who's really crossing the line here? The defense or the bench? Let's find out. Let's unpack what we just witnessed, because this hearing wasn't just about a search warrant. It was about credibility, ethics, and courtroom power. From the very beginning, Martell's motion was risky. He tried to argue that Judge Boyd's prior involvement, signing a search warrant, disqualified her from overseeing the preliminary exam. But here's the thing. Under Michigan law, that argument usually doesn't fly. Judges sign warrants all the time based solely on affidavits. That process is ex parte, meaning one-sided, based on paperwork, not live testimony. So, unless the judge actually heard witnesses or formed opinions about the case, there's no conflict. The prosecution immediately recognized this. They cited multiple precedents, including People v. Cameron, 2013, and People v. Pitchford, 1971, both confirming that signing a warrant doesn't mean a judge is biased. In fact, even in cases where the same judge reviewed search evidence and later oversaw the trial, the ruling stood. What made this moment explosive was not the law itself, but the tone. Judge Boyd didn't just disagree with Martell. She accused him of lying to the court, saying he misrepresented facts about her prior involvement and twisted case law to suit his narrative. That's serious, because in any courtroom, mischaracterizing the record, intentionally or not, undermines trust. Judges depend on lawyers to present the truth accurately, and when a judge feels manipulated, the fallout can be brutal. Boyd even warned Martell that filing frivolous motions could lead to sanctions, meaning fines or ethical consequences. Then came the emotional turning point. She accused him of forum shopping, trying to steer the case away from her to another judge he might see as more favorable. That's a major professional red flag. If true, it suggests strategy over substance, and most courts see that as an abuse of process. But credit where it's due, Martell didn't completely fold. He pushed back respectfully, saying he meant no disrespect and only wanted to preserve his client's rights. Still, by that moment, the tone had shifted. You could feel it. The courtroom wasn't just a space for arguments. It had turned into a test of integrity. The ruling. Boyd demanded a written motion by December 10th, with a hearing set for January 2nd. That's her way of saying, if you're serious, prove it on paper. From a legal standpoint, this case is a fascinating example of how judicial objectivity is balanced against defense advocacy. Martell's job is to challenge potential bias. That's his duty. But the way he did it, citing incomplete case law and misstating details, damaged his credibility. Meanwhile, Boyd's composure, though stern, demonstrated a firm grasp of judicial ethics. She maintained authority without crossing into personal bias, a line that's hard to hold under pressure. So the bigger question becomes, where's the line between zealous defense and courtroom misconduct? Should an attorney risk angering the judge to protect a client's right to a fair trial? Or does professionalism mean knowing when to stop? What do you think? Did Martell go too far, or was he just doing his job? One thing's for sure. This case is far from over. The written motion and January hearing could reshape everything depending on how it's filed, and if the judge decides it was frivolous, Martell might face more than just a denied motion. He could face disciplinary review. Either way, Judge Boyd's message was clear. Don't play fast and loose with my courtroom.